All rise, vous le levez. The International Residual Mechanism for Criminal Tribunals is now in session. L'audience du mécanisme international appelé à exercer les fonctions résiduelles des tribunaux pénaux est ouverte. Please be seated.
Good morning. Register, could you please call the case?
Good morning, Your Honors. This is case number MICT-15-96A, the prosecutor versus Jovica Stanišić and Franco Simatović. Thank you, Your Honors.
Thank you. Good morning again. I'm Judge Graciela Gatti, the presiding judge assigned to this case. My colleagues, Judge Lee G. Mutoga, Aminata Runenin Gum, Judge Yusuf Aksar, and Judge Claudia Hofer are the other judges of the appeals chamber seized of this case. Mr. Stanisic, can you hear the proceedings in a language that you can understand?
Da, časni sude.
Yes, Your Honor.
Mr. Simatović, can you hear the proceedings in a language that you understand?
Da, časni sude.
Yes, Your Honor.
Well, before proceeding with the appearances of the parties, the appeals chamber, with Mr. Stanisic's written consent, has exceptionally authorized his legal assistant, Mr. Joe Holmes, to represent Mr. Stanisic for for today's hearing. Mr. Wayne Jordash, Mr. Stanisic's counsel, has been authorized to attend via conference link. And in addition, the appeals chamber has also granted Mr. Simatovic's request to attend today's pronouncement via video conference link from the United Nations Detention Unit in The Hague. So I will now ask for the appearances of the parties, and first, please, the prosecution.
Good morning, Your Honors. Laurel Begg for the prosecution. I'm joined by my colleagues, Counsel Alison de Bruer, Counsel Sarah Horan, and Counsel Christine Keller, and we're with our case manager, Janet Stewart.
Thank you. Now, counsel for Mr. Stanisic.
Good morning, Your Honours. Wayne Jordash for Mr. Stanisic and Joe Holmes.
Thank you. Now, counsel for Mr. Simatovic.
Dobro jutro.
Good morning, Your Honors. Good morning to everyone in and around the courtroom. Today, the Simatovic defense will be represented by Vladimir Petrovic and myself, Mihailo Bakrać. Thank you.
Thank you. Well, today, the appeals chamber pronounces the judgment in the case of prosecutor versus Jovica Stanisic and Franco Simatovic, pursuant to Rule 144D of the Mechanism's Rule of Procedure and Evidence. This pronouncement makes a milestone in Mechanism's mandate to continue the material, temporal, and personal jurisdiction of the International Criminal Tribunal for the former Yugoslavia, or the ICTY, which closed in 2017. The appeals chamber presently pronounces the last appeal judgment in connection with cases originally within the ICTY's jurisdiction involving international crimes committed in the territory of the former Yugoslavia since 1991. I will now read a summary of the judgment. This summary does not constitute any part of the official and authoritative judgment. The judgment will be distributed to the parties after today's hearing is adjourned. And as background, proceedings against Stanisic and Simatovic commenced before the ICTY in 2003, when both were indicted and first arrested. A trial chamber of the ICTY acquitted Stanisic and Simatovic of all counts of their indictment on 30 May 2013. On 9 December 2015, the ICTY Appeals Chamber granted, in part, the prosecution's appeal, quashed Stanisic's and Simatovic's acquittals, and ordered a retrial on all counts of the indictment. Following initial appearances and pretrial proceedings, retrial before the trial chamber of the mechanism commenced in June 2017 and concluded with the pronouncement of the judgment on 30 June 2021. The trial chamber filed the written trial judgment on 6 August 2021. During the events relevant to this case, Stanisic served as a deputy chief and later chief of the State Security Service of the Serbian Ministry of the Interior, which I will refer to as the State Security Service. Simatovic was one of the State Security Service's senior intelligence officers. The trial chamber found that through organizing the training of and then deploying Serb forces in connection with the takeover of Bosanski Samac in Bosnia and Herzegovina in April 1992, Stanisic and Simatovic aided and abetted the charged crimes committed in this municipality, which included, among other acts, arbitrary detentions, forced labor, beatings and torture, sexual violence, and murder against the non-Serb populations. The crimes and violence forced non-Serbs to flee the municipality. The trial chamber convicted Stanisic and Simatovic of counts 1 to 5 of their indictment for murder as a violation of the laws or customs of war, as well as murder, persecution, deportation, and forcible transfer as crimes against humanity. The trial chamber sentenced each to 12 years of imprisonment. Stanisic and Simatovic have appealed these convictions and their sentences. As the prosecution also charged Stanisic and Simatovic with joint criminal enterprise, or JCE, liability, the trial chamber further determined that from at least August 1991 and at all times relevant to the crimes charged in the indictment, a plurality of persons shared a common criminal purpose to forcibly and permanently remove the majority of non-Serbs from large areas of Croatia and Bosnia and Herzegovina through the commission of the crimes of persecution, murder, deportation, and forcible transfer charged in the indictment. The crimes covered by the indictment occurred in Croatia on the territory of the former Serbian autonomous regions of Krajina, referred to as SAO Krajina, and of Slavonia, Baranja and Western Srem, or SAO SBWS. In Bosnia and Herzegovina, the crimes were committed in the municipalities of Bijeljina, Zvornik, Bosanski Shamac, Doboj, and Sanski Most, and in an area near the village of Trnovo. While the trial chamber found that the conduct supporting Stanisic's and Simatovic's aiding and abetting convictions for crimes committed in Bosanski Shamac also contributed to the common criminal purpose, it concluded that the prosecution had not proven beyond reasonable doubt that either shared the intent to further the common criminal purpose. Consequently, the trial chamber did not convict either on the basis of JCE liability. It also did not find them criminally responsible on any other basis. The prosecution appeals Stanisic's and Simatovic's acquittal for JCE liability, or alternatively, the trial chamber's failure to convict them for aiding and abetting crimes committed in SAO Krajina, SAO SBWS, Doboj, and Sanski Most. Following the conclusion of written appeal submissions, the appeals chamber heard the parties' oral submissions on 24 and 25 January 2023. I shall now provide a summary of the most salient aspects of the judgment, commencing with Stanisic and Simatovic's appeals against their convictions. To provide context, I will set out the trial chamber's findings that are central to their criminal responsibility. The trial chamber found that by at least August or September 1991, Stanisic and Simatovic formed the unit, which served as a state security service combat unit that operated under their command and control, and that they determined its use and deployment until at least mid-April 1992. It concluded that around late 1991, Stanisic and Simatovic established the Lezimir training camp in Fruška Gora, Serbia, and then established the Pashos training camp across the border in Ilok, Croatia. The trial chamber found that the camps operated under their authority until at least March or April 1992. The trial chamber further determined that at the Lezimir and Pashos camps, unit members trained approximately 20 locals from Bosanski Shamac and a group of former police officers from SAO SBWS, and that this latter group was incorporated into the unit in March 1992. The trial chamber concluded that on or around 10 April 1992, Simatovic addressed unit members and locals from Bosanski Shamac. Stanisic and Simatovic were found to have authorized the deployment of this group of about 50 people to Bosanski Shamac, which has then subordinated to the Yugoslav People's Army, or the GNA. Starting on 17 September 1992, this group, with other Serb forces, participated in the takeover of this municipality and committed crimes charged in the indictment. The trial chamber found that by training and deploying the group, Stanisic and Simatovic provided practical assistance that had a substantial effect on the perpetration of the crimes committed in Bosanski Shamac. It also concluded that both knew that their acts assisted the commission of the crimes and were aware of the essential elements of the crimes, including the intent of the perpetrators. The trial chamber convicted them of aiding and abetting the crimes of persecution, murder, deportation, and forcible transfer on this basis. I will now turn to Stanisic's appeal of these convictions. Through grounds 1 and 2 of Stanisic's appeal, he challenges the trial chamber's conclusion that the actus reus of aiding and abetting liability in relation to the takeover of Bosanski Shamac has been established. He contends in ground 1 that the trial chamber erred in law in failing to assess his remoteness from the practical assistance he was found to have provided, and the remoteness of that assistance from the crimes committed in Bosanski Shamac, emphasizing that he was not present during the training or deployment. In ground 2, Stanisic argues that the trial chamber erred in fact in finding him responsible for the organization of training at the Lezimir and Pashos camps and the subsequent deployment of unit members and local Serb forces to Bosanski Shamac. He also challenges the trial chamber's conclusion that the training and deployment provided practical assistance which had a substantial effect on the crimes committed in Bosanski Shamac. As detailed in the judgment, the appeals chamber finds that Stanisic has failed to demonstrate that the trial chamber erred in law or fact in finding that his actus reus for aiding and abetting crimes committed in Bosanski Shamac was established. Grounds 1 and 2 of his appeal are dismissed. Grounds 3 and 4 of Stanisic's appeals challenge the trial chamber's conclusion that he possessed the requisite intent for aiding and abetting liability. He submits that the trial chamber lowered the applicable mens rea standard by failing to consider several factors and by confining its analysis to his knowledge of prior crimes and awareness of the general probability of future crimes occurring in Serb military operations. Stanisic further contends that the trial chamber erroneously placed undue weight on pattern evidence of preceding crimes committed in Croatia and Bosnia and Herzegovina in late 1991 and early 1992, given the absence of compelling similarities with the planning, preparation, or execution of the crimes committed in Bosanski Shamac. He claims that the trial chamber failed to give sufficient weight to factors that the training and deployment could have been for legal activities, the absence of his involvement in planning the takeover and crimes, and the absence of criminal intent of the principal perpetrators during the training and deployment. For reasons explained in the judgment, the appeals chamber finds that Stanisic has not shown that the trial chamber was legally required to consider factors he lists when making findings on his mens rea, or demonstrate that it erred by lowering the mens rea standard. He also has not demonstrated that the trial chamber erred in finding that the mens rea for aiding and abetting the crimes in Bosanski Shamac had been established. Grounds 3 and 4 of his appeal are dismissed. I will now turn to Simatovic's appeal against his convictions. Parts of round 1 of Simatovic's appeal allege that the trial chamber erred in relation to findings principally concerning his positions with the State Security Service and his conduct unrelated to events in Bosanski Shamac. The appeals chamber dismisses these challenges, finding in most instances that Simatovic's allegation of error, if substantiated, would not lead to a miscarriage of justice or invalidate his convictions or sentence. Aspects of grounds 1 and 2 of Simatovic's appeal also challenged the trial chamber's finding that he aided and abetted the crimes committed in Bosanski Shamac. In particular, in material respects, Simatović argues that the trial chamber erred in concluding that he formed the unit and that it operated under his control, erred in relying on evidence from 2 accomplice witnesses, erred regarding the training conducted at the Pashos and Lezimir camps, as well as his authority over the camps and the unit, erred as to his role in the briefing and the deployment of unit members and local Serb forces to Bosanski Shamac, and erred in failing to sufficiently account for the GNA's involvement in the training and deployment. Simatović also contends that the trial chamber erred with regard to findings on the composition and training of the unit and local Serb forces and his awareness of the crimes committed in Bosanski Shamac. The appeals chamber finds that the trial chamber erred in finding that the locals from Bosanski Shamac were trained at the Lezimir camp, but that Simatović has not demonstrated that this error has occasionated a miscarriage of justice. As to his remaining contentions, the appeals chamber finds that Simatović has failed to demonstrate that the trial chamber erred with respect to the conclusions he challenges on appeal. Simatovic's submissions regarding his aiding and abetting liability for crimes committed in Bosanski Shamac are set out in grounds 1 and 2 of his appeal, are dismissed. Finally, the appeals chamber dismisses Simatovic's challenges developed principally in ground 4 of his appeal, that the trial chamber erred by incorrectly applying the law with respect to aiding and abetting liability, or that it erred in a number of evidentiary decisions taken during the trial proceedings. And now I will turn to Stanisic's and Simatovic's sentencing appeals. Ground 5 of Stanisic's appeal alleges that the trial chamber, without providing adequate reasoning, abused its discretion and imposed a manifestly disproportionate sentence of 12 years of imprisonment by erroneously assessing the gravity of the offenses and failing to individualize the sentence based on his remote and minimal contribution to the crimes. He argues that the trial chamber erroneously relied on sentences from ICTY cases that were incompatible to his circumstances and failed to consider other more appropriate sentences. For reasons explained in the judgment, the appeals chamber finds that Stanisic has not demonstrated that the trial chamber erred in its assessment or otherwise imposed an unreasonable sentence. Rounds 6 to 8 of Stanisic's appeal challenged the trial chamber's assessment of mitigating circumstances. The appeal chamber finds that Stanisic, given his failure at trial to make submissions on mitigating circumstances, waived his right to raise new mitigating circumstances on appeal and argued that the trial chamber erred in failing to consider them. Having considered Stanisic's challenges to the mitigating circumstances, the trial chamber did consider, the appeals chamber finds that he has not demonstrated error. The appeal chamber dismisses grounds 5 to 8 of Stanisic's appeal. Round 3 of Simatovic's appeal challenges the trial chamber's decision to sentence him to 12 years of imprisonment. He contends that the trial chamber erred in assessing the gravity of the offenses, his abuse of authority as an aggravating circumstance, his mitigating circumstances, as well comparing his case with other ICTY cases. He also argues that the trial chamber erroneously imposed the same sentence on him and Stanisic by failing to account for the difference in their respective positions of authority and roles at the time of the events. The appeal chamber finds that Simatovic has not demonstrated any error in the trial chamber's assessment of relevant factors in the determination of his sentence. The appeal chamber dismisses ground 3 of Simatovic's appeal. And now I will briefly summarize the prosecution's appeal. In ground 1A, the prosecution submits that the trial chamber erred in law in assessing what constitutes a contribution to the common criminal purpose, failed to adjudicate or provide a reasoned opinion on alleged contributions, or otherwise erred in failing to find that Stanisic and Simatovic contributed to the common criminal purpose to forcibly and permanently remove the majority of non-Serbs from large areas of Croatia and Bosnia and Herzegovina in ways beyond their contributions to Bosanski Shamac. In ground 1B, it contends that the trial chamber committed errors of law and fact in failing to find that they possessed the requisite mens rea for JCE liability. In grounds 2A and 2B, the prosecution argues that the trial chamber erred in law and or fact in failing to convict Stanisic and Simatovic for aiding and abetting crimes committed in SAO Krajina, SAO SBWS, Doboj, and Sanski Most. Finally, grounds 1C and 2C request that the appeals chamber declare that the trial chamber erred in law in limiting the prosecution's evidence primarily to that presented during the original trial. Several arguments under ground 1A relate to the trial chamber's assessment of Stanisic's and Simatovic's alleged contributions to the common criminal purpose in connection with crimes committed in Sanski Most in September 1995. Specifically, the prosecution alleges that the trial chamber failed to adjudicate or provide a reasoned opinion as to whether Stanisic and Simatovic deployed 300 to 400 men to operations in the area that includes Sanski Most. It also challenges the trial chamber's determination that the prosecution was not pursuing forcible displacement charges in connection with crimes committed in Sanski Most in September 1995. The prosecution further argues that the trial chamber committed legal and factual errors by failing to find that Stanisic and Simatovic contributed to the common criminal purpose by financing the Serbian volunteer guard in relation to murders of 75 non-Serbs committed in Sanski Most in September 1995. For reasons explained in the judgment, the appeals chamber dismisses arguments related to the deployment of 300 to 400 Serb forces and the trial chamber's determination that the prosecution was not pursuing forcible displacement charges in connection with events in Sanski Most in September 1995. However, the appeals chamber finds that the trial chamber committed a legal error by restricting its analysis to whether the prosecution had proven that the State Security Service paid Serbian volunteer guard members who participated in the commission of the 1995 killings in Sanski Most charged in the indictment, but by not assessing contributions to the Serbian volunteer guard that might have otherwise significantly contributed to the furtherance of the common criminal purpose in connection with those killings. Having reviewed the record, the appeals chamber finds that the prosecution has eliminated all reasonable doubt that, starting from at least December 1994 and throughout 1995, and in particular around the time of the charged murders in Sanski Most, the State Security Service paid 1. Individuals who led and or delivered money to the Serbian Volunteer Guard, 2. A significant number of Serbian Volunteer Guard members, and 3. Substantial sums to the Serbian Volunteer Guard around that time. As elaborated in the judgment, the appeals chamber also concludes that the prosecution has eliminated all reasonable doubt that Stanisic and Simatovic were jointly responsible for the payments around the time of the charged murders committed in Sanski Most, and that, through the payment, both significantly contributed to the furtherance of the common criminal purpose, and in particular, the charged murders. The appeals chamber recalls that the significance of an accused contribution to the common criminal purpose is relevant to assessing the accused mens rea in connection with their alleged JCE liability. As the trial chamber did not consider Stanisic and Simatovic's contributions to the common criminal purpose in connection with the charged murders in Sanski Most in September 1995, its mens rea findings regarding their intent for JCE liability are deficient and must be re-evaluated. The appeals chamber has therefore evaluated key pieces of evidence as well as the trial chamber's consideration of such evidence when it concluded that it had not been established that Stanisic and Simatovic possessed the shared intent to further common criminal purpose. Having conducted this review, and for reasons explained in the judgment, the appeals chamber concludes that all reasonable doubt has been eliminated that at least from the time Stanisic and Simatovic organized the training of unit members and local Serb forces at the Pajos camp and their subsequent deployment during the takeover of Bosanski Shamac in 1992, and continuing through the period involving the commission of crimes in Sanski Most in September 1995, Stanisic and Simatovic shared intent to further the common criminal purpose to forcibly and permanently remove the majority of non-Serbs from large areas of Croatia and Bosnia and Herzegovina through the commission of the crimes charged in the indictment. All reasonable doubt has also been eliminated that both Stanisic and Simatovic possessed the intent to commit the underlying charged crimes. Consequently, the appeals chamber grants, in part, ground 1 of the prosecution's appeals and finds Stanisic and Simatovic responsible under Article 1 of the Mechanism Statute and Article 7.1 of the ICTY Statute for committing based on their participation in a JCE. As a result, Stanisic and Simatovic are liable for charged crimes committed by principal perpetrators whose conduct is attributable to Stanisic and Simatovic or other members of the JC. Based on a review of the findings of the trial chamber and the relevant record, these include charged crimes committed in Bosnia and Herzegovina, in Bijeljina, starting at the end of March 1992, in Zvornik in April 1992, in Bosanski Shamac, starting in April 1992, in Doboj in May 1992, in Sanski Most in April and May 1992, in Chernobyl in July 1995, and in Sanski Most in September 1995. The Appeals Chamber also finds that Stanisic and Simatovic are liable for a murder committed in Dajska Planina, SAO SBWS, Croatia, in June 1992. As GCE liability most appropriately reflects the full scope of Stanisic's and Simatovic's criminal conduct in connection with the crimes committed in Bosanski Shamac, the Appeals Chamber sets aside their aiding and abetting convictions based on the same conduct. The Appeals Chamber dismisses the remainder of the prosecution's appeal, alleging errors related to Stanisic's and Simatovic's contributions to the joint criminal enterprise, their aiding and abetting liability, and the trial chamber's decision to limit the presentation of new evidence in the retrial. The Appeals Chamber has considered the impact of Stanisic's and Simatovic's increased culpability in assessing the appropriateness of their sentences. In evaluating all the relevant circumstances, the Appeal Chamber observes, for example, that Stanisic and Simatovic have not been found to be involved in the planning or execution of any of the crimes for which they have been convicted. Nor has it been established that either directed or had authority over any of the perpetrators as the crimes were committed. Finally, the Appeals Chamber has determined that the sentence of 12 years of imprisonment imposed on each by the trial chamber tends toward the higher range of what is reasonable exercise of sentencing discretion. This circumstance carries significant weight in the Appeals Chamber's sentencing considerations. I will now read the disposition. So, Mr. Stanisic, please stand up. And Mr. Simatovic, as you are following from the United Nations Detention Unit, please, you can remain seated because of technical reasons. Well, for the foregoing reasons, the Appeals Chamber, pursuant to Article 23 of the statute and Rule 144 of the rules, noting the written submissions of the parties and their oral arguments presented at the hearing of the appeals on 24 and 25 January 2023, sitting in open session, dismisses Stanisic and Simatovic's appeal in their entirety. Grants in part ground 1 of the prosecution's appeal and finds Stanisic and Simatovic guilty under Article 1 of the statute and Articles 3, 5, and 7.1 of the ICTY statute for committing, based on their participation in a joint criminal enterprise, first category, the following crimes charged under counts 1 to 5 of the indictment. 1, deportation, human acts, forcible transfer, and persecution as crimes against humanity committed in connection with the takeover of Bijeljina. 2, murder as a violation of the laws or customs of war, as well as murder, deportation, inhuman acts, forcible transfer, and persecution as crimes against humanity committed in relation to the takeover of Zvornik. 3, murder as a violation of the laws or customs of war, as well as murder, deportation, inhuman acts, forcible transfer, and persecution as crimes against humanity in connection with and following the takeover of Bosanski Shamac. 4. Inhuman acts, forcible transfer, and persecution as crimes against humanity committed during the takeover of Doughboy. 5. Deportation, inhuman acts, forcible transfer, and persecution as crimes against humanity committed in Sansky Most in April and May 1992. 6. Murder as a violation of the laws or customs of war, as well as murder and persecution as crimes against humanity committed in Tarnovo in July 1995 and Sansky Most in September 1995. And 7. Murder as a violation of the laws or customs of war, as well as murder and persecution as crimes against humanity for the killing of Marinja Senasi in Dajska Planina, SAO SBWS in June 1992. Sets aside the trial chamber's finding that Stanisic and Simatovic are responsible under Article 1 of the statute and Article 7.1 of the ICTY statute for aiding and abetting the crimes charged under counts 1 to 5 of the indictment committed in Bosanski Shamats. Dismisses the prosecution's appeal in all other respects, sets aside Stanisic's sentence of 12 years of imprisonment and imposes a sentence of 15 years of imprisonment, subject to credit being given under Rules 125C and 131 of the rules for the 2,634 days spent in detention as of May 31, 2023. Sets aside Simatovic's sentence of 12 years of imprisonment and imposes a sentence of 15 years of imprisonment, subject to credit being given under Rules 125C and 131 of the rules for the 3,048 days spent in detention as of 31 May 2023. Rules that this judgment shall be enforced immediately pursuant to Rule 145A of the rules, and orders that, in accordance with Rules 127C and 131 of the rules, Stanisic and Simatovic shall remain in the custody of the mechanism pending the finalization of the arrangements for their transfer to the state where their sentences will be served. The case is then concluded and the hearing is adjourned.
All rise, voulez-vous lever?
You are the only participant.